Subscribe now and press the bell icon. Never miss an update.
Ready? 5 seconds. The plaintiff thereafter states that he wished to construct residential house building for his own occupation adjacent to the property as per agreement, which is very close to his proposed residence. Plaintiff is alleged to have made solid arrangement for the same. It was specifically inter alia stated that the plaintiff had arranged balance consideration and he was continuously ready and willing to take the assignment right from the date of the agreement, that is on 24 March 2007 and thereafter in future as well. We further notice that on 24 March 2008, which as per XA1 agreement was to be the last date under the agreement, the plaintiff and the defendant claimed that they were present at the office of the sub-registrar. According to the plaintiff, the defendant was elusive and could not be contacted over the phone and he was unavailable. The plaintiff filed a complaint before the police on 24 March 2008 in the evening. He also followed it up with a petition before the sub-registrar on 25 March 2008. Within 3 days from 24 March 2008, that is on 27 March 2008, the present suit came to be instituted claiming specific performance. In the plaint, after referring to the agreement, the plaintiff has alleged that he was already ready and willing to perform his obligations. The blame was put at the doorstep of the defendant for breaching the contract. The defendant, in his written statement, on the other hand, blamed the plaintiff for breach, and it was his case that plaintiff was not ready and willing and he was not ready with the funds. The trial court struck the following issues: whether the plaintiff was ready and willing to perform his part of the contract, whether the defendant committed breach, and whether the plaintiff is entitled to get a decree for specific performance. The trial court inter alia found as follows: it is true that plaintiff has not produced any document to show that he was having ready cash covering the balance consideration payable by him under XA1 at the relevant time. Of course, certain documents are produced to show that presently he is having some ready cash in the form of fixed deposits and in the form of share certificates, etc. I do not think that any of these documents are much relevant in this case, for the reason that in the nature of the dispute, the plaintiff has to prove his capacity to pay the balance consideration within the period shown in XA1. It is further stated that the plaintiff had orally offered to the defendant in the presence of witnesses that he will take assignment of the property even before the stipulated date for which the defendant is ready. The plaintiff caused a reply notice to be sent to the aforesaid Lloyd's notice. The reply notice sent was dated 18 March 2008. Therein, it is relevant to notice certain statements. After referring to X-A1 agreement, it is stated that the Lloyd's notice was sent by the defendant without getting the property measured or producing and convincing the plaintiff about the original title deed number 1405/1975 as well as prior documents. It is stated that the plaintiff was and is continuously ready and willing to perform his part of the agreement right from the beginning till then and in future. The statement in the notice sent by the defendant is denied that the plaintiff will take the assignment before the agreed date and it was agreed so in the presence of witnesses. It is alleged that defendant sent the notice with ulterior motive, concealing that property had not been measured and without producing the original title deed. The plaintiff pointed out that the defendant consented to measure the property only 3 days before that date, that is on 16 March 2008. It may be noticed that reply notice is dated 18 March 2008 and it was sent only later. It was further stated that the defendant told the plaintiff that the total extent of property as per the document found on measurement was only 70.950 cents. The case measurement sought to be set up further is that according to the plaintiff, 1 cent of property was not in the possession or ownership of the defendant. Out of the 70.950 cents of property, 1 cent on the southern boundary was alleged to belong to one Kochamu and another half cent of property on the northern boundary belonged to someone else. This information was got by plaintiff from reliable source. The plaintiff complains in the reply notice that the defendant was insisting that he will assign the property only if the consideration in full for the said 70.950 cents was paid. Objection was taken to the same by the plaintiff. Thereafter, it is inter alia stated that the plaintiff is ready and willing to take the assignment of the entire property available as per the original document number 1405/1975.
Subscribe now and press the bell icon. Never miss an update.